To remedy the harm caused by discrimination, you can receive damages, which is monetary compensation, as well as non-monetary relief. The damages and relief that your employer is responsible for is its liability. In this video, I'll walk you through all that you may be entitled to because of the discrimination you experienced. Not that you'll ever get all that, but it's good to know where to start the negotiations. In discrimination cases, restitution exists in 7 forms. Monetary relief is back pay and front pay. Compensatory damages is financial reimbursement for bills, lost opportunities, emotional harm, and other intangible harms. Punitive damages is money paid by an employer to punish and discourage any future discrimination. Liquidated damages is the financial penalty for failure to follow particular laws. Declaratory relief includes statements from an employer decrying the discrimination. Injunctive relief consists of particular actions an employer must take or refrain from, such as reinstatement or anti-discrimination training for management. And finally, attorney's fees. All anti-discrimination laws provide for injunctive relief, declaratory relief, and attorney's fees. Title VII and the ADA also provide for compensatory and punitive damages, while the ADEA and EPA allow for back pay and liquidated damages. For discharge, failure to hire, and promotion cases, the largest financial loss is the loss of salary. Back pay is money you would have received in wages if not for the discriminatory act. In the case of a promotion denial, back pay is the difference between your salary and what your salary would have been if you had been promoted. Back pay includes all monetary compensation for work. So in addition to straight salary, that includes bonuses, raises, overtime, commissions, tips, vacation time, and stock options. The back pay period starts with the adverse action. For continuing actions under Title VII and the ADA, the earliest the back pay period can start is 2 years prior to the filing of the discrimination charge. The back pay period is halted temporarily if you receive another job with a higher salary or experience a period of incapacitation due to something like a pregnancy, illness, or injury. Attending full-time school would not be a period of incapacitation if you were still looking for work and would quit school if you found a job. Several circumstances permanently halt the back pay period, along with the possibility of reinstatement and front pay. If your former employer makes an unconditional offer to reinstate you to substantially the same position and you reject the offer. This offer must have no strings attached, like reapplying for the job or dropping the complaint. The offer is not valid if unrealistic for reasons such as a strong animosity between you and your employer, or because you would be required to move far away. If you voluntarily resign, if you would have been separated anyway because of something like a plant closure, if after acquired evidence justifies your termination, as I discussed in the video about proving discrimination. To receive the full amount of back pay, you must attempt to find another job. You have a responsibility to try to mitigate, that is, reduce your damages through interim earnings. Starting a business, sending out resumes, and completing job applications all demonstrate mitigation. Your interim wages will be subtracted from the back pay amount when determining damages. Income from an evening or night shift job would only be subtracted if you could not have held this position while working for the discriminatory employer. As you search for work, save copies of job applications, the names and telephone numbers of employers you contacted, and rejection letters. These documents show you attempted to mitigate your damages. Ultimately, your former employer has the responsibility of proving that you did not mitigate your damages. You are entitled to interest on the total of your back pay, less any interim earnings. You can compute interest on this mitigated back pay amount using the U.S. prime rate. In addition to back pay, you can receive front pay, which is lost wages projected into the future. Front pay is available if you are not offered reinstatement or reinstatement is impossible because of the antagonistic relationship between you and your employer. Front pay is rarely included in settlement agreements. Compensatory damages comprise the largest portion of the restitution typically awarded in discrimination cases. Compensatory damages consist of tangible financial losses and intangible non-financial losses. Compensatory damages generally cannot be collected for harm occurring more than 2 years prior to the date a charge of discrimination is filed. Your employer is responsible for tangible expenses you paid as a result of the adverse action, such as medical expenses because of doctor's visits, medicines, and therapy treatments, job search costs like mileage, clothes, and retraining, increased commuting costs for your new job, relocation expenses, including the cost of travel to visit relatives that previously lived nearby, value of lost pension benefits, employment perks, such as the value of a lost company car, expenses from foreclosures and repossessions, interest on loans taken due to the loss of income. Save your receipts, bills, and canceled checks to document these costs. Discrimination causes non-monetary harm that cannot be easily quantified. How can a price tag be placed on emotional harm, mental anguish, or the loss of dignity? To determine the degree of emotional injury, courts consider the existence, nature, and severity of the harm. Types of emotional harm include loss of professional standing, injury to reputation, reduced employment opportunities, injury to credit rating, inconvenience due to your commuting to a new job or being forced to move, loss of self-respect and self-confidence, loss of enjoyment in life, like when spending time with friends or family. There are many physical and mental symptoms of emotional harm. I won't list them all here, but you get the idea. At the EEOC, every single person I spoke with about filing a charge of discrimination experienced at least one of the symptoms I've listed. If you are experiencing any of these symptoms, I just want to encourage you to keep a few things in mind. Most people are discharged at least once in their career. Jobs come and go, but an employer cannot take away the things that really matter: your friends, your family, your beliefs, and your integrity. And after a rough patch, you may find yourself in a better position. To certify emotional harm, visits to medical personnel are best. Even a single visit to a psychiatrist, therapist, or physician soon after the discriminatory act can establish a record of the emotional harm. Documents indicating the diagnosis and prognosis, which is whether symptoms will worsen, improve, or remain stable over time, are very helpful in this regard. Keep any bills, receipts, or canceled checks relating to treatment or consequences of the harm. If necessary, friends, neighbors, coworkers, and family members can testify about the emotional toll. For settlement purposes, emotional harm is reduced to a dollar amount. Garden variety emotional harm that doesn't require medical evidence typically results in a verdict around $20,000. Great evidence of significant emotional harm typically results in a court verdict of about $40,000 to $50,000. Even for serious sexual harassment, it is uncommon for courts to award more than $100,000 for emotional harm. In federal court, out-of-pocket and emotional harm damages are subject to a maximum amount. The cap on damages for compensatory and punitive damages combined depends on the size of the employer. Even if a jury awards a higher amount, a federal court will reduce the verdict for these types of damages to fit under the maximum cap. Many states do not have caps on damages, and most discrimination cases are filed in state court for this reason. Punitive damages are to punish employers for demonstrating malice or reckless indifference to your federally protected rights. Cases with direct evidence are prime candidates for punitive damages. Large damage awards are mainly due to punitive damages. The wealth of the employer is a key element in determining the amount of punitive damages, as are the outrageousness of your employer's conduct, the degree of harm to you, and your employer's response to your protests. Government agencies are exempt from punitive damages. Punitive damages are also not applicable in disparate impact cases or when discrimination is not intentional. The Age Discrimination in Employment Act, ADEA, and the Equal Pay Act, EPA, provide for liquidated damages to penalize an employer for discriminatory actions. The amount of liquidated damages is equal to the back pay amount and are instead of interest on back pay. To calculate the amount of back pay and liquidated damages combined, simply double the mitigated back pay amount. For ADEA cases, liquidated damages are available when your employer demonstrated a knowing and reckless disregard for the ADEA. Discharging an older complainant with a record of great performance and replacing them with a younger, less qualified employee demonstrates a willful violation. Cases with direct evidence are good candidates for liquidated damages. In EPA cases, liquidated damages are common and are available for the 2 years prior to the date a lawsuit is filed. If your employer demonstrated a knowing and reckless disregard of the EPA, this time frame is extended to 3 years. Liquidated damages are not available against government employers. Declaratory relief is basically an apology by an employer. As much as you might love a public apology from your employer, declaratory relief is uncommon. Written declaratory relief is particularly rare. Aside from an apology, any other non-monetary relief is injunctive relief. The chief purpose of injunctive relief is to place you where you would have been absent the discrimination. So this includes reinstatement, hiring, and promotion. Other examples of injunctive relief are expunging the record of an undeserved disciplinary action, writing a positive letter of reference, providing sensitivity training to a discriminator or harasser, granting a reassignment or transfer, and changing a policy or practice. The costs of employing an attorney are recoverable as damages. Even if you lose the most important part of your case in court, winning another significant part of your case could make you eligible for attorney's fees and court costs. Attorney's fees resulting from work accomplished while the case was being investigated by a government entity are legitimate attorney's fees. Damages in mixed motive cases are limited. Mixed motive cases are cases in which discrimination occurred, but the employer would have taken the same adverse action for reasons wholly unrelated to the discrimination. The damages available in mixed motive cases are declaratory relief, some forms of injunctive relief, and attorney's fees. You are required to pay taxes on all income received, but there's a tax advantage to damages other than back pay. Federal and state withholdings can be withheld from back pay, like Social Security and workers' compensation. Compensatory and punitive damages avoid these withholdings. You can deduct from your taxes expenses paid for the production of taxable income, such as expenses leading to a settlement agreement. Attorney's fees paid directly to your attorneys by your employer as part of a settlement agreement still must be reported by you as income. However, this income can also be written off as a deduction. But just to be clear, not only does this video not constitute legal advice, it does not constitute tax advice either. So now, when you are making your opening offer and settlement negotiations, you can list off all the different types of damages you're entitled to, and then show how reasonable you are by your willingness to accept less than that. I'll talk more about settlement in my next video. Thanks for tuning in.